This is Barry Zalma on insurance. Today I'd like to speak about the contract of personal indemnity. First-party property insurance is defined as a contract of personal indemnity. The insurer promises to indemnify the first party, the insured, in the event the insured incurs a loss as a result of one of the perils insured against by the wording of the policy. Insurance does not follow title to the land. The insurer makes a promise to the first party, the insured, that if there is a loss to property in which the insured has an interest, to pay indemnity for the loss. The elementary principle of insurance law, that fire insurance is a contract of personal indemnity and not one from which a profit is to be realized. The insurance claims adjuster must always ascertain that the owner, or a person with some other insurable interest in the property, is the person insured, and that the person insured has an interest in the property. Failure to do so could result in the insurer paying the wrong person or paying a person with no right to the benefits promised by the policy. Proceeds of a policy upon the interest of an insured are not subject to the claims of others who have an interest in the property but are not named as insured, or who do not qualify as insureds by definition. A first-party property policy is considered by courts asked to interpret the conditions of the policy to be one of personal indemnity. It is a contract made with the individual to be protected. The insurance does not go with the property as an incident thereto to any person who may buy the property. If it goes at all, it goes as a matter of contract for the transfer of the policy. In the estate of Cartwright versus Standard Fire Insurance Company, a 2008 decision of the Tennessee Court of Appeal, the contract of insurance was found to be purely a personal contract between the insured and the insurance company, and does not attach to or run with title to the insured's property, absent an agreement for the transfer of the policy. It is an elementary principle of insurance law that fire insurance is a contract of personal indemnity, not one from which a profit is to be realized. The right to recover must be commensurate with the loss actually sustained. For example, in practice, consider a fictional Mrs. Jones who is allowed to live rent-free in a home owned by her children. Mrs. Jones purchases in her name alone a policy of homeowners insurance, insuring her against the risks of loss to the structure and its contents. If a fire destroys the house, Mrs. Jones can recover, because her interest in the house is an insurable interest. This means she has an interest in the property that it will allow her to recover for the loss of property if it is lost, damaged, or destroyed. Mrs. Jones' children, the owners of the home, also have an insurable interest in the home, but are not insured under Mrs. Jones's policy, and therefore may not recover any proceeds from her policy. In California, as in most states, in common parlance, we speak of a house as being insured, but, strictly speaking, it is not the house, but the interest of the owner therein that is insured. And whether the interest is founded upon a legal title, an equitable title, a lien, or such other lawful interest therein as will produce a direct and certain pecuniary loss to the insured by its destruction, he has an insurable interest therein. only a person who is both an insured and who has an insurable interest may obtain indemnity from a policy of first-party property insurance. In Russell versus Williams, a 1962 decision of the California Supreme Court, the statement of the law was clear. It is a principle of long standing that a policy of fire insurance does not insure the property covered thereby, but is a personal contract, indemnifying the insured against loss resulting from the destruction of or damage to his interest in that property. The property is not insured against destruction. The insured is guaranteed against loss to the extent of his insurable interest not exceeding the amount stated in the policy's declarations page as the limit of liability promised by the insurer. As the betterments and improvements installed in the building pass to the owner at the expiration of the lease, in part consideration for the rent, the tenant could not sell them or remove or recover their value. The insured, therefore, had a limited insurable interest, the right to use them until the expiration of the lease, while the owner would have a 100% insurable interest in the property. As a contract of personal indemnity, the policy only insures the person named in the policy against certain risks of loss of property in which that person has an interest. A person who has an interest in the property but is not named as an insured cannot recover under the policy. Similarly, a person named on a policy who has no interest cannot recover. No one can recover indemnity on a first-party property policy unless they have an insurable interest in the property and are named as an insured, or by definition are an insured of the policy. It may be said generally that anyone has an insurable interest in property who derives a benefit from its existence or would suffer loss from its destruction. An insurable interest in property is any right, benefit, or advantage arising out of or dependent thereon, or any liability in respect thereof, or any relation to or concern therein of such a nature that it might be so affected by the contemplated peril as, in the words of the California statute, to directly damnify the insured. The ancient language damnify merely means to hurt or somehow cause a damage to the property. The term interest, as used in the phrase insurable interest, is not limited to property or ownership in the subject matter of the insurance. An insurable interest in property may arise from some liability which an insured incurs with relation thereto. Such liability may arise by force of statute or by contract, or may be fixed by law from the obligations which insured assumes. Moreover, an insurable interest in property does not necessarily imply a property interest in, or even a lien upon or possession of the subject matter of the insurance, and neither title nor a beneficial interest is requisite to the existence of such an insurable interest. It is sufficient that the insured is so situated with reference to the property that he or she would be liable to loss should it be injured or destroyed by the peril against which it is insured. For instance, although a person has no title, legal or equitable, in the property, and neither possession nor right to possession, yet he has an insurable interest therein if it is primarily charged in law or equity with a debt or obligation for which he is secondarily liable, or for which he has a lien upon the property, or for which the property stands as security for a loan. Insurable interest is a keystone of the concept of insurance, safeguarding the insurer against the risk that arises if one who will receive the monetary benefit from loss of the insured property, or life in the case of life insurance, has no interest in the property not being destroyed. For example, I could purchase from any insurer a policy insuring against the loss of your house or your apartment by fire. And if it was destroyed by a fire, I still couldn't collect because I have no interest in your house. And I'm not hurt in any way by your house being burned down. You are. And if you have insurance, you can collect, but I cannot. Therefore, it is well settled across the United States that having title or an ownership interest is not the sole basis for having an insurable interest. For instance, I could have loaned you $1 million based on the security of your house. Then I would have an insurable interest. Rather, the test of insurable interest. Originally, the statutory requirement of insurable interest was intended to prevent wagering on human lives. The test of insurable interest in property is whether the insured has such a right, title, or interest therein or relation thereto, that he will be benefited by its preservation and continued existence, or suffer a direct pecuniary loss from its destruction or injury by the peril insured against. Originally, the statutory requirement of insurable interest was intended to prevent wagering on human lives with regard to life insurance. The concept was soon expanded to property insurance. No insurance contract on property, or of any interest therein or arising therefrom, shall be enforceable except for the benefit of the persons having at the time of the loss an insurable interest in the things the risk of loss of which was insured. To have an insurable interest, the insured must derive a direct pecuniary loss from the subject matter of the contract. The loss cannot be indirect or sentimental. An insurable interest in an insurance policy is determined not by the label attached to the insured's property, but by whether the insured will suffer a pecuniary loss due to the destruction of the property. For example, Florida, by statute, Section 627.405(2), provides, quote, "No contract of insurance of property, or of any interest in property, or arising from property shall be enforceable as to the insurance except for the benefit of persons having an insurable interest in the things insured as at the time of loss." Insurable interest as used in this section means any actual, lawful, and substantial economic interest in the safety or preservation of the subject of the insurance free from loss, destruction, or pecuniary damage or impairment. The measure of insurable interest in property is the extent to which the insured might be indemnified by loss, injury, or impairment. This was stated in Accident Cleaners versus Universal Insurance Company, a 2015 decision of the Florida Court of Appeal. Similarly, California by statute defines insurable interest as follows, quote, "Every interest in property or any relation thereto, or liability in respect thereof, of such a nature that a contemplated peril might directly indemnify the insured, is an insurable interest. This is California Insurance Code Section 281. This video was adapted from my book, Zelma on Insurance Claims, Part 101, 3rd edition, which is available as both a Kindle book, a paperback, and even a hardcover from Amazon.com. If you found this video to be useful or interesting, please pass it on to your colleagues. It's free. And please also subscribe to my YouTube channel, clicking on the like button if you found it worthwhile, and on my Rumble channel, clicking on the Rumble button if you found it worthwhile, as well as my blog and my Substack publications. Thank you for your attention.